if the president decides that his rival is a corrupt person and he orders the military or orders someone to assassinate him, is that within his official acts that for which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
It could, and why? Because he's doing it for personal reasons. He's not.
And folks, that right there is Donald Trump's attorney, John Sauer, arguing in front of the United States Supreme Court today that a president could theoretically order the assassination of a political opponent, and that action, him ordering the assassination, could be covered by an official act absolute immunity doctrine that Sauer is actively advocating for on behalf of Donald Trump. This morning, the United States Supreme Court heard oral argument in the Trump absolute immunity case, and there are just some wild clips and oral arguments that came out of the case. But for some top lines from this case, remember, this case, by background, arises out of Special Counsel Jack Smith's investigation into Donald Trump's actions leading up to and on January 6, 2021. The case had been on pause in front of Judge Chutkan for several months while Trump's attorneys have appealed the charges, arguing that they should be dismissed because Trump has absolute immunity under the United States Constitution for all official acts taken. And according to Trump's attorneys, all of the acts, or most of the acts charged in the indictment, are considered to be official acts, and therefore the indictment should be dismissed. But today, a couple key top lines. Number one, Trump's attorneys did concede that not all of the charged actions are official acts, and therefore at least some of them were taken in Trump's personal capacity such that he could be tried for those crimes, for those alleged crimes, even though some others were considered to be official acts. That's number one. Number two, the United States Supreme Court, at least a few of the justices seem to agree with Trump's attorneys, especially Justices Kavanaugh, Thomas, and Alito all seem to agree that the special counsel's prosecution of Donald Trump, at least part of it, was unconstitutional. Justice Gorsuch seemed to also agree, just not as strongly, while Justice Roberts and Justice Barrett were kind of more so in the middle, where they were looking for a compromise, where maybe Jack Smith's prosecution moves forward just on the unofficial, the personal acts, while striking the official acts from the indictment. But if that compromise were to come to bear, it would delay the trial for several months, likely past the 2024 election, because it would take a long time for District Judge Tanya Chutkan to parse through the allegations, hold an evidentiary hearing to really determine what is an official act versus what is a private act. But ultimately that right there, that delay is what Trump's attorneys are seeking. Now, the three liberal justices, Justice Jackson, Kagan, and Sotomayor, all signaled that they will not uphold this doctrine of absolute immunity. They threw out some pretty crazy hypotheticals like the one we saw earlier about the potential assassination of a presidential opponent, while they also threw out a hypothetical about what would happen if Donald Trump or a president stole national security secrets. Watch that clip here.
If a president sells nuclear secrets to a foreign adversary, is that immune?
That sounds like, similar to the bribery example, likely not immune. Now, if it's structured as an official act, he would have to be impeached and convicted first before.
What does that mean if it's structured as an official act?
Well, I don't know in the hypothetical whether or not that would be an official act. You'd probably have to have more details to apply the Blazing Game analysis or even the Fitzgerald analysis that we've been talking about.
Now, as you can see here, even now, after that clip, John Sauer was still defending this absolute immunity argument to the extent that so long as the president taking these state secrets in his official capacity, that may grant him absolute immunity. But that was also not the only one. There was also a question posed about whether or not a president creating a slate of fake electors would be subject to this absolute immunity doctrine. Watch what John Sauer had to say.
What is plausible about the president assisting in creating a fraudulent slate of electoral candidates? Assuming you accept the facts of the complaint on their face, is that plausible that that would be within his right to do?
Absolutely, Your Honor.
And that comes at a really critical time because just yesterday, as you may know, Rudy Giuliani, Mark Meadows, and other top Trump officials were actually indicted in Arizona for participating in and conspiring in a fake elector scheme to overturn the Arizona 2020 election results in an effort to overturn the presidential election results at large. Now, Rudy Giuliani, Mark Meadows, and others face several felony charges in Arizona that could land them in Arizona State Prison, including conspiracy, forgery, and others. And that indictment is very similar to the Georgia RICO indictment that District Attorney Fani Willis brought against Meadows, Giuliani, and others last year. Now, Giuliani, Meadows, and the Trump officials have yet to appear in an Arizona court for an arraignment, but expect them to be arraigned and have their mugshot taken in the coming weeks. And as soon as we have more information on that, I'll provide it to you. But one other key fact in that indictment is that Donald Trump was actually named as an unindicted co-conspirator. What that means is that the Attorney General likely had enough evidence to charge Donald Trump as a co-conspirator if it wanted to. However, in this case, there were several factors for why Donald Trump would not be charged as a co-conspirator here, especially given the fact that he is currently facing 4 other criminal prosecutions in a number of other jurisdictions. Now, back in New York, Donald Trump has had other legal troubles today that we need to talk about. Number one is that David Pecker continued to testify on the witness stand as part of Donald Trump's hush money criminal trial in New York City. And number two, Donald Trump's request to set aside or have a new trial in the E. Jean Carroll defamation case was denied by Judge Kaplan. Donald Trump currently owes E. Jean Carroll upwards of $80 billion in damages. He sought to have a new trial issued in the case or for what is called a judgment as a matter of law. Both were denied. Donald Trump will now likely appeal to the Second Circuit and later to the United States Supreme Court. Now, outside of the legal news regarding Trump, the big news on the other side is really the protests that are breaking out across universities on campuses across the country. We still have protests ongoing in Columbia, at USC, at the University of Texas, George Washington University joined today, and more as students continue to build these encampments in an effort to promote pro-Palestinian voices. However, many of these university protests have turned violent and have also spread anti-Semitism using anti-Semitic rhetoric like globalize the Intifada and from the river to the sea to call for the extermination of the state of Israel and by proxy to call for the elimination of the Jewish people. University officials are currently grappling with how to respond to these protests, and while some, for example in Texas, have used law enforcement to crack down, others, like at Columbia in New York, have been hesitant to allow law enforcement to come on campus to handle the protesters and the agitators. As always, this is all the news you need to know in under 10 minutes. If you like this content, be sure to like this video, subscribe for more, comment below your thoughts, and as always, stay tuned for all the news you need to know.